Right, so welcome everyone. I think this is the second CIPIL event we're having this term. We had one, I think, last week, more on information law and ranking digital rights project. This one is completely different. It's much more my area. That's why I'm going to be chairing this one. This is on international intellectual property law and questions of economic development in particular. I'm very happy to be able to present to you Professor Carlos Correa. Those of you who are in my class will certainly have seen references to the writings of Carlos Correa in the handouts, and I think I'm not wrong to say that Carlos is one of the most eminent experts on international intellectual property, in particular the TRIPS agreement, in particular looking at international IP law from a development perspective. Carlos has done lots of work with various international organizations, WIPO, WTO, and I think you have also been involved to some extent in negotiating TRIPS, at least indirectly, right?
No, directly.
Even directly. And one thing, I mean, there's lots of information I could pick out. Just one thing I want to pick out is Carlos was also involved in the UK government report on intellectual property and development, a report from 2001, if I'm not mistaken, which is, now almost 50 years old, but still has a lot of very relevant information in it, and it's a very useful tool. And it's been sort of written by a commission of experts. Carlos was one of them. And with that, I'll just leave it and look forward to hear from you about whether intellectual property causes development. Thank you.
Well, thank you very much, Gary, for the generous introduction. Good afternoon to everybody. I'm very glad to be here. Thank you for the invitation. So let me just make two introductory observations. The first one is that you can interrupt me if you wish, if you have questions during the presentation. So there's no need to leave them for after I finalize. And the second one is that I will present one view about the relationship between intellectual property and development. Of course, there are different views. You will have people that perhaps has a more optimistic view or a positive view about this relationship. As you will see through my presentation, my conclusion on the basis of literature and empirical evidence which is available is that this relationship is not as strong as is sometimes argued about. Well, then we have here two concepts, intellectual property and development, and we want to link them. So you know already what intellectual property is about, because we're studying intellectual property, and then I understand that you have mainly focused so far in the area of copyright, and not so much in patent law.
In the international intellectual property course, we have done copyright, and we have looked at some general aspects, treaty interpretation, and so on and so forth. For those who are, but there's lots of other people here, but I think it's a fair assessment that most will be quite familiar with questions of IP law. Yeah.
All right, because when we talk about relationship between intellectual property and development, we will focus mainly on innovation rather than on copyright works. This is at least the area that has been studied mostly by scholars. Okay, so we know what intellectual property is, you know what intellectual property is, and then what about the concept of development? So what we do understand by development? Well, of course, this concept is perhaps more difficult to define. The concept has evolved over the years. The concept that was used 40 or 50 years ago is not the same that is now prevailing in international discussions on the subject. And I just brought here some elements of a very recent declaration by UN, the declaration on the 2030 Agenda for Sustainable Development, where there is an expression of what developing and developed countries understand by the concept of development, which is in fact both a process and an objective. Then if we look at what the diplomats have concluded, which is on the screen, they have identified 4 elements to define what development is. So in the first place, regarding people. So the objective is to end poverty and hunger in all their forms and dimensions, and to ensure that all human beings can fulfill their potential in dignity and equality and in a healthy environment. Second element is planet. The objective is to protect the planet from degradation, prosperity, to ensure that all human beings can enjoy prosperous and fulfilling lives, and that economic, social, and technological progress occurs in harmony with nature, and peace, to foster peaceful, just, and inclusive society which are free from fear and violence. So these are the elements that the diplomas have identified as constituting the concept of development. As you can see here, and it was not in fact present some years ago, the idea that there should be sustainable development is critical now, and Professor Vinales is an expert in this field. So the idea that development must be associated with the protection of the planet, protection of the environment, and not just the development that may contribute to harming or to the degradation of the planet. So the development in the end means prosperity. So we have to define this other concept, or means progress, economic, social, and technological progress. So we have a general idea that development means that there is an improvement in the conditions of life of the people under some circumstances. Okay, but then when there is when we need to examine this relationship between intellectual property and development, a conventional argument would say that intellectual property promotes innovation, okay, and creativity. But let's focus here on innovation. Then the second assumption would be that innovation contributes in some way or some form to reduce poverty, improve public health, address climate change, and achieve other objectives. So the underlying idea that innovation has positive impact in different areas, which may include those which are referred to here. And then if this is so, then intellectual property contributes to development, because it through innovation, through promoting innovation, it does contribute to development. So we could add some elements. How is it that intellectual property promotes innovation? Today, the main argument would be that this is done through promoting research and development, or providing incentives for the private sector in particular to invest in research and development. So this investment in research and development is the basis for innovation, which contributes to solving public health problems, environmental problems, so on and so forth. And then this is the contribution to development. Okay, so these are very complex relations, in fact. And we may, of course, study the relation between innovation and development on the one hand, and then the relationship between innovation and intellectual property as such, and how it in the end contributes to development. So regarding innovation and development, I'm not going to focus on this question because it's quite complex, and there is a lot of literature, especially in the area of economics of innovation, that addresses this issue. There are different models or theories about the sources of innovation. There is a model that argues that innovation is forced by the supply, or is mainly incentivized by the supply, and there are some models that, on the contrary, assume that innovation is really demand-driven rather than supply-driven. That means that it's not the scientists or the technological people that will create innovations on their own, on the basis of their own interest, but the innovation is an outcome of actual demand in the market. So different models try to explain what are the determinants of innovation. And also, we must take into account that innovation may play a role in economic and social development to the extent that there is a diffusion of these innovations. So that means that the knowledge, the technologies are disseminated. So in terms of development, just to innovate is not enough. For instance, if you consider a developing country, and if you look at the case of medicines, if there is innovation, if a new medicine is developed, there might be a contribution to development to the extent that this medicine is accessible to the people in that particular country. But innovation without availability or accessibility does not mean development, does not mean any improvement in the social or economic conditions of the people. For instance, as you probably know now, there has been a new drug has been developed for hepatitis C. So millions of people suffer from hepatitis C all over the world. And the cost of the treatment, a few weeks treatment, is in the United States, for instance, is $84,000 US. So each pill is more than $1,000. So the innovation is there, but this is not enough in terms of development when innovation is not affordable, it's not accessible. So that's one consideration we need to take into account. And secondly, I don't know the extent to which you are familiar with economics of innovation, but there is a distinction that economists do between invention and innovation. Not every invention leads to innovation. In economics of innovation, innovation means that the technology is put into practice. So there is innovation when there is technological change because something is produced, a new service or a new product is put on the market. And in fact, most patents which protect inventions are never applied effectively. So in most cases, patents do not lead to actual innovation, thus remain as a title, providing some protection for certain knowledge, but it does not lead to actual innovation. So the concept I will use here is innovation as understood by most economists, meaning that it's an actual application of the new technology and not just the development of knowledge that may or may not be applicable. Okay, so we are not going to go deeper into this question, but what I will try to discuss with you is then the relationship between intellectual property and development, just assuming that intellectual property has some role in relation to innovation. So we are going to discuss the extent to which intellectual property actually promotes innovation. And we will just consider as a basic assumption that innovation may lead in some cases to development, but as I mentioned before, depending on the conditions under which innovation is actually disseminated in a particular country. Well, now the situation with intellectual property is, as you, I'm sure you know, that because of the TRIPS agreement, which was adopted in the context of the World Trade Organization, there are minimum standards in the area of intellectual property which are applicable to all countries which are members of the World Trade Organization. So at this point, this means that countries have little room for maneuver. Members of WTO, which is more than 160 members, have to apply minimum standards. So it means that there is no great possibility of differentiation with regard to the level of protection between developed and developing countries, with the exception of least developed countries, which have been exempted from the implementation of the TRIPS agreement. Recently, there has been a decision extending the transition period for least developed countries. But then one element that we need to consider when we look at this issue of innovation as an outcome of intellectual property and its relationship with development is that we have this platform. There is this basis, minimum standards that all countries need to apply, and therefore there is no significant room for differentiation. And then the second observation is that when this agreement was adopted in 1994, the proponents of the agreement argue that having these minimum standards for the protection of patents, trademarks, copyrights, etc., will do some positive things, will promote global innovation, will promote foreign direct investment to developing countries, and will also promote transfer of technology. So if you look at the records of the negotiation of this agreement, you will see that the proponents, which were clearly the developed countries, argue that having minimum standard would have positive impacts in terms of more innovation, global innovation, not only in developed countries but also in developing countries, and that it will also promote foreign direct investment and technology transfer. There are some studies, in particular econometric studies, that have been conducted in relation to these issues. For instance, foreign direct investment and the strength of intellectual property or transfer of technology. I'm not going to refer to these studies. I do not trust very much the econometric studies because they do not prove anything. They just prove that there is a correlation, but we don't know whether there is a cause and effect between the terms in which are studied. I will focus on innovation and then what the impact of these global standards have been in terms of innovation in developed countries and in developing countries. And I will offer as an example the case of pharmaceuticals. So, to start with some figures, when the TRIPS agreement was negotiated, the distribution of research and development at the global level was such that 94% of research and development expenditures was concentrated in 1994 or around 1994 in developed countries. So you are familiar with the concept of research and development. As you know, there are statistics about this. OECD in particular, they collect, they organize statistics on this, on the basis of the so-called Frascati manual. And so these statistics allow us to know how much effort is done by different countries in terms of developing new science and technology. Developed countries such as United States or Germany, they invest around more than 2% of the GDP in research and development. But one of the features at the global level when the negotiation of the TRIPS agreement started was that there was a major asymmetry between developed and developing countries in terms of their capacity to create new science and technology. So major asymmetry, much more important in the case of trade, for instance. Developing countries participate in global trade more than this percentage. And at that time that was the case too. But in terms of investment for research and development, the asymmetry between developed countries and developing countries was really huge. As you can see, only 6% of global R&D was done in developing countries. And of course, developing countries were conscious that adopting the TRIPS agreement would to some extent freeze the advantages of developed countries. Because in the end, the aim of the proponents was to ensure that the outcomes of their own research was protected in developing countries. That's why these minimum standards were established. Okay, then, if the argument was that the TRIPS agreement would increase innovation, both in developed and in developing countries. If we look at the statistics about investment in research and development, which, as I mentioned, are collected mainly by OECD, also there is an organization in the United States that follows these statistics, we will see that the increase in research and development in developed countries during this period has been quite modest. We look, for instance, at what the United States invested in R&D at that time, and what the United States is investing today, it has had a very small increase. But the same for European countries, or Japan. So if we look at R&D in developed countries, we cannot actually say that because of these international rules, there have been more research and development in those countries. But then we may look at developing countries. So was it true that the TRIPS agreement would promote innovation in developing countries? Then if we look at statistics, and the statistics in some cases are not very updated because it takes some time to elaborate them. The last available is for 2012. If these statistics indicate that in 2012, developing countries accounted for 22% of global research and development. So the immediate conclusion would be, well, something important has happened, and maybe the proponents of the TRIPS agreement were right that these international rules on IP would promote innovation at the global level. But if we look more in detail at these figures, we will see the following picture. OECD countries, that means developed countries, will still control most of it. 78% of R&D is actually done in developed countries. Then you have Asia, which accounts for 19% of the global research and development, but this is very important. Look at China. China now accounts for 11.8% of the global R&D, global research and development. So this is an impressive change in the area of research and development. Sometimes we think of China as a country that is just imitating, or is just producing goods on the basis of subcontracting or foreign technologies. But we must know that China is investing very heavily in research and development. If the rate of investment of China continues as it is today, in 2020, China will invest in research and development more than the United States, and especially is investing a lot in the area of energy, among others. But then, Latin America accounts for 2.4%. Brazil is almost half of it in terms of research and development. The near Middle East, 1.2%, and Africa, even less than 1% of the global research and development. Then the conclusion is, although the share of developing countries in research and development has increased, this can only be explained by the role of China. So if you exclude China from those statistics, in the rest of developing countries, there has been practically no increase in terms of research and development, or very little, very marginal. So we cannot actually say that the TRIPS agreement, these international standards on intellectual property, have actually promoted more innovation in developing countries. But let's look at another possible indicator, and this indicator is really a poor one, and this is the number of patent applications made in different countries, high level, high income. Well, this is following the World Bank classification of countries in high income, upper middle income, lower middle income, and low income countries. Well, if you look at the percentage of patent applications made in 2003 and 2013, this is based on a study published by WIPO last year, we will see that the share of developed countries in patent applications has fallen between 2003 and 2013 from 85.7% to 60%. So the share of developed countries in terms of patent applications has clearly gone down significantly. The share of upper middle income countries has gone up from almost 12% to a little more than 36%. So now there are more filings, patents made in upper middle income countries. There are 39 upper middle income countries. But if we take these upper middle income countries and we exclude China again, so we count only upper middle countries without China, then the number of patent applications has actually decreased from 5% to 4%. So again, these statistics may be misleading if you don't take into account the particular case of China. And if you look at lower middle income countries, these are 31 countries, there has been a very small increase from almost 2 to 3%, and low income countries, the share of patent applications is still very low and has gone down a little. Okay, so this means that we cannot really say again that the TRIPS agreement, one of the important chapters in the TRIPS agreement, as you know, is the chapter on patents, has actually promoted more patent applications in developing countries if we exclude China. And China is the country today that receives the largest number of patent applications in the world, and the country that grants the largest number of patents in the world. But then, a couple of considerations on these statistics. First, a patent application does not mean necessarily innovation. A patent application may be accepted or refused. In some countries there is no examination, such as in South Africa, but in most countries there is an examination, such as in Europe, as you know, or the United States, and then many patent applications never become a granted patent because they do not comply with the requirements of novelty, inventive steps, and so forth. So this is just about patent applications. Secondly, in the case of developing countries, more than 80%, in some cases 90% of patent applications are in any case done by foreign companies, not by locals. So even if we consider these statistics, we must take into account that most patent applications made in countries such as Egypt, Argentina, Brazil, India, etc., are done by foreigners and not by local, by nationals. It depends. In low-income countries is 95% or 98% foreigners, and just very few from locals. In India or in countries with some technological development, even more, maybe 80%. But in any case, this should be taken into account while looking at these statistics. And finally, the third element is that there is, as you probably know, a major issue regarding what is called patent quality. So is a patent really a good indicator of innovation? And most economists will say clearly, no, they are not a good indicator of innovation. Because in some cases, the technologies are never put in practice, and because in many cases, patent offices are very lax in granting patents. So they grant patents on the basis of an analysis which is very superficial or very lax of the patentability criteria. And I will show you just 3 examples of how low the level of inventive step that is required. For instance, this is a patent granted in the United States. I will give you a minute for you to read. Well, what do you think? Is this really inventive? Huh? You consider, and this was, this is interesting, is IBM. Huh? IBM is one of the companies with the largest number of patents applied for and granted in the United States, so very active in patenting. So they got this patent. Well, it's not clear whether there is a very high inventive step. This is a British patent. Huh? So this child here, Sam, was considered the youngest living inventor. When he was 5 years old, he invented what you can see there on the slide. He was lucky enough because his father is a patent attorney. Then when he discovered that his son was a genius or an inventor, he rushed to the patent office, the UK patent office, and got the patent. This is from a British journal, newspaper. So this is another example. Can we say that really Sam has made a real contribution to technology? Can we consider a patent a good indicator of technological change? Just to show you another example, also coming from the United States. As you know, animals can be genetically modified. But in this case, what was patented is not the animal, but the cat. The cat as applied is an animal cat apparatus and method. And this is what? Of course, this is for fun, but the problem is that the US Patent Office, for instance, is well known because they apply a very low level of non-obviousness. So they grant patents like this also in the area of pharmaceuticals or agrochemicals, because they are not really seeking a very high level of inventive step in order to grant a patent. So the point I'm making is that if we look then at the statistics on patent application, patent grants as a measure of innovation, we may be wrong, because the fact that the patent has been applied doesn't mean anything, and the fact that the patent has been granted, it may not mean too much, depending on the level of inventive step that is required by the specific patent office. But now, one of the sectors that really pushed a lot in order to get a TRIPS agreement was the pharmaceutical industry from the United States and Europe. I would personally say that there would be no TRIPS agreement without the action of the pharmaceutical industry. So the pharmaceutical industry organized itself in order to push the government of the United States, and then the government of the United States convinced the European communities and Japan in order to develop in GATT these international rules on intellectual property. So I would say that without the pharmaceutical sector's involvement in this issue, there will probably be no TRIPS agreement today. And the reason for this is that pharmaceutical industry consider that patents in several areas, such as state data, are essential in order for them to innovate, in order for them to invest in research and development, because costs of research and development are significant, sometimes are exaggerated. Some figures say it's more than $1 billion US per drug for a new drug, but this is not confirmed because there is no clear evidence. But in any case, it's very clear that the pharmaceutical industry is one that has been very much behind this idea of strengthening and expanding intellectual property protection on the argument that this is the basis in order to promote more innovation. If you wish more innovation in health, if you want more innovation in medicines, then the argument was we need an international system of protection for intellectual property. Well, they got that because the TRIPS agreement was adopted, and in one of the main provisions in the TRIPS agreement is contained in Article 27, Paragraph 1, which indicates that patents must be granted in all fields of technology. And then this changed a situation where in many countries there was no patent protection for pharmaceuticals. So it was a major victory for the pharmaceutical industry in terms of obliging all members of WTO to grant patents in the area of pharmaceuticals. But then let us look at what happened with innovation in the pharmaceutical industry, major actor in developing these international rules. Well, here we have a slide showing the number of new chemical entities developed between 1994 and 2014. So these new chemical entities are the real innovation, because the pharmaceutical industry also does what is called incremental innovation in terms of developing new salts or polymers or isomers of existing drugs. But this is really marginal, it's routine, there is not big inventive step in any case. So the real innovation, if there is one, takes place when a new drug is developed. Then if we look at this slide, so we can see that between 1994 and 2000, the average of new chemical entities was around 40 per year. But if we look after 2000, 2002 in particular, we can see that the average is above 20 per year. So the impact, we cannot say, of course, this is an impact of the TRIPS agreement, but what we can say that the TRIPS agreement and the international rules on intellectual property have not promoted more innovation in the pharmaceutical industry, but on the contrary, there has been a decline of innovation in this industry. So the reason for this may be complex, the fact that in some cases the current tools of scientific technological tools are not sufficient, the fact that a lot of money is invested but very little outcome is obtained. Whatever the reasons are, the fact is that if we look at the pharmaceutical industry as a major proponent of international protection of intellectual property, what we can actually see is that innovation in that sector has declined, not has increased. But if we go deeper and look into what the pharmaceutical industry is producing, I don't know whether it's clear enough. Well, this is a study trying to find out of those new chemical entities, out of those new drugs, which are really important in therapeutic terms. Because a new drug may address a disease for which there is an existing drug. So the contribution of a new drug is very little. Perhaps it will be more expensive, and the companies will convince the doctors to administer the new drug instead of the old one, but in terms of public health or health impact, it may be minimal. So this study shows that most of the new drugs which are developed by the pharmaceutical industry do not represent a real contribution in terms of health. Most of these drugs just do the same as other existing drugs, in some cases with no benefits for the patient. Perhaps they will be, as I said, more expensive, but no benefit. So if we consider not only the number of drugs, but also the quality of innovation, we can see that has not changed anything in terms of the low level of innovation as regards the impact that the new drugs may have in terms of health. You see there here, the positive therapeutic value, which is in blue, is a very small proportion of all drugs, which were developed in those periods. This starts in 1981, and the last one is 2006-2010. This part is neutral therapeutic value. That means that it doesn't add anything to what existed before, and in some cases, in accordance with this study, there may even be negative therapeutic value. That is, the side effects and others, which means that the innovation has no positive impact. Well, going on with the pharmaceutical sector, there is another interesting study by two scholars, one from Columbia University and the other one from University of Pennsylvania, about the efficacy of these drugs, of the new drugs. And then they found that by the 1980s, drugs were less than 4 times better than placebo. You know what placebo is? Yeah? By the 1990s, twice as good. And by the 2000s, just 36% better than a placebo. So that means that in terms of efficacy, it is not only that we have less, the number of drugs has declined. It is not only that most of these drugs are what is called the industry me too's, that means that there are already treatments for the same disease, but also about the efficacy. Well, these scholars have found that they are not as efficacious as previously. And there is also evidence that innovation in the pharmaceutical industry depends significantly on research done by public institutions, and not only by private institutions. For instance, most cancer drugs have been developed by public institutions, and then the industry takes them and make the clinical studies, which are expensive. But the basic research, the basic molecules are in general found by the public institutions or small biotech companies. And this is a statement from Martin Wolf, who is a very well-known journalist. He said, innovation depends on bold entrepreneurship, but the entity that takes the boldest risks and achieves the biggest breakthroughs is not the private sector, it is the much maligned state. So arguing that it is not, if there is innovation, this is not an outcome of intellectual property or private investment. And then finally, an aspect that is of particular relevance for developing countries. As I mentioned before, the argument was, with these international rules, there will be more innovation at the global scale, including developing countries. But one concern of developing countries relates to innovation that addresses the diseases that prevail in developing countries. Which diseases prevail in developing countries? Some of you are coming from developing countries.
Malaria.
Malaria, for instance.
TB.
Tuberculosis. Malaria, tuberculosis, Chagas. There is very little research and development in these areas, and very little outcome. So,
what about HIV?
HIV, well, there is more interest because HIV is also prevalent in developed countries. So there is more research in HIV.
But there are different types, right? So the type prevalent in Africa is not the same as the one prevalent in Europe and the US. So the research done on types relevant in the US may not necessarily be significant for treating the disease in Africa. I mean, that's something I heard, I'm not sure.
Well, that's the issue, that the patent protection stimulates research in the areas where there are rich markets. The patent protection does not stimulate research to develop drugs which should be consumed by poor people. And then there is this element in the system, and therefore, in terms of innovation, which is relevant for developing countries, we cannot say after 20 years of the TRIPS agreement that there has been any increase of innovation in the area of pharmaceuticals for diseases that prevail in developing countries. Well, this is a statement made by a commission that was set up by the Assembly of the World Health Organization, which indicate that there is no evidence that the implementation of the TRIPS agreement in developing countries will significantly boost research and development in pharmaceuticals and type 2 and particular type 3 diseases. These are the diseases that prevail in developing countries. Insufficient market incentives are the decisive factor. That means that patents work when there is a rich market. Patents do not work as an incentive where such markets do not exist. Okay, so this is the experience with the pharmaceutical industry. And just to add an additional information, the argument was made that strengthening patent protection or creating in particular patent protection for pharmaceuticals would make some countries such as India to become major players in the area of pharmaceuticals or developing new drugs in the area of pharmaceuticals. Well, the evidence after 20 years is that in India, which is a major producer of medicines, as you probably know, is a major supplier of medicines, especially for developing countries at low cost. In India has been no research and development on new molecules because the companies are not interested in trying to develop new drugs. What they do is to do some derivatives, as I mentioned before, improvements on existing drugs. So the pharmaceutical industry in India has not been incentivized by the patent system to produce new drugs because the economics of producing new drugs is such that it is not a business that these companies are interested in pursuing. But what the Indian companies do is to develop around existing drugs. These are the improvements I mentioned before, for instance, a new salt for an existing drug, so on and so forth. Then there is a study made by Mani and Nelson. I don't know whether you recognize the name of Richard Nelson. He's one of the biggest economists in innovation. And then this book concluded, they examined in particular the extent to which the TRIPS agreement on the incorporation of patents in India has promoted research and development in pharmaceuticals, and they concluded that TRIPS may have accelerated research and development related to improvements of medicines, but they say, in the absence of TRIPS, such activities would still have been undertaken. With larger domestic operations, Indian companies would have had access to larger resources and would have been better placed to undertake such research. So in other words, well, yes, there have been improvements. The company have worked in this area, but they could have done it better without the protection conferred by patents. So in other words, there is no positive income. Well, let me just start with then what economists think. So this is a view about the pharmaceutical industry in particular. But now I will show a number of quotes from economists from developed countries, especially from the United States, about the relationship between intellectual property, innovation. In some cases, they have also examined the relationship between intellectual property and development. And I just wanted to start with a Nobel Prize, Gary Becker. I don't know whether I'm familiar with his work. He got the Nobel Prize because of work in the area of human capital. And Gary Becker, surprisingly, as well as another Nobel Prize, Joseph Stiglitz, they have become very strong critics of the intellectual property system. Gary Becker, for instance, he said that the current patent length of 20 years, longer for drug companies, from the date of filing for a patent can be cut in half without greatly discouraging innovation. So he's just proposing the patents, as you know, last in general for 20 years. They may be extended in some jurisdiction for pharmaceuticals, which is a positive discrimination for pharmaceuticals. But then this economist is arguing that this is too much for promoting innovation. 10 years would be sufficient. But then the relationship between intellectual property and development, including industrial development, has been studied from a historical perspective by many scholars. And I will just present a few of the conclusions that they have reached. But before that, I just also wanted to present you this paragraph from a study which was made by a United States official body. This was the United States Office of Technology Assessment, an office that operated within the Congress of the United States. But they produced this study about intellectual property rights in the age of electronics and information, where they argued that when the United States was still a relatively young and developing country, it refused to respect international intellectual property rights on the grounds that it was freely entitled to foreign works to further its social and economic development. So it's a clear recognition by one agency of the United States that when they were developing, they didn't really wanted a system of intellectual property, but they just wanted to use flexibility in order to get technologies from abroad. When you visit Washington, D.C., it would be good for you to visit the Museum of Industry and Arts. And there you will find a room which is bigger than this one, where it is shown in a very candid manner how the United States industrialization process started on the basis of technologies that were brought from England. So it's shown in a very candid manner how the United States was able to imitate, even with sending people, especially in order to spy and to get technology, and this was the very beginning of the industrialization process in the United States. Not local development, not research and development, but the absorption and later improvement of technologies from UK. Then a study by, if you look at copyright, we have already studied copyright. I don't know whether you know that the United States refused to grant copyright to foreigners until 1891. You know whether you have studied this? Yes? You know? Okay, so there is no need for me to emphasize this. But this is very curious because this was a very deliberate policy by the United States. They knew that they were discriminating foreigners and locals, but it was a policy in order to allow the distribution of cheap but excellent books, with the idea that there was no inherent property in relation to literature and books. So this was the policy followed at that time. Then Petra Moser made a very extensive study about the impact of intellectual property. The study is Patents and Innovation, Evidence from Economic History, published in 2013, and one of the conclusions is that overall the weight of existing historical evidence suggests that patent policies which grant strong intellectual property rights to early generations of inventors may discourage innovation. On the contrary, policies that encourage the diffusion of ideas and modify patent laws to facilitate entry and encourage competition may be an effective mechanism to encourage innovation. So these historical studies have led to the conclusion that this assumption that patents or intellectual property necessarily promotes innovation may not be true. Then on the basis of this research, the conclusion is that competition may be more important than the appropriation of knowledge on the basis of intellectual property. There is another study in 2010. A survey of 72 countries was conducted, and one of the conclusions of the study is that today there is no robust empirical evidence that stronger patent rights indeed stimulate growth. So here there is an attempt to make the relationship between patent protection and economic growth, and the conclusion reached by the authors was that there is no evidence that may establish that link between patent protection or stronger patent protection and economic growth. This is a very recent study published this year, 2015, titled is very suggestive. Do stronger intellectual property rights increase innovation? Which should be then the basis of development. And then these authors found that tested the impact of ever more rigorous intellectual property rights systems on innovation through an index of economic complexity in 19 countries from 1965 to 2005. This is study done. And then the conclusion is the paper offers evidence that developing countries have not enjoyed the benefits of global IPR standardization. So they do some interesting analysis, and they conclude that unlike argued by the proponents of the TRIPS agreement, the harmonization, the minimum standards have not been to the benefit of developing countries. Well, Baldwin and Levin, two scholars from the United States, they also did a historical study. And as you will see, these two guys are quite critical of the system. And they concluded in 2007 that historical evidence provides little or no support for the view that intellectual monopoly is an effective method of increasing innovation. In fact, it is quite surprising, because if you look at the economic literature regarding intellectual property produced in the United States, most of the literature is along these lines. So it's an overwhelming. So there might be some economists that may have different views, but it's really surprising, in particular for people like me coming from developing countries, the extent to which the economists in the United States in particular are skeptical, very skeptical, about the impact that intellectual property has on innovation. So I have, of course, there are too many quotes. I didn't want to bring so many, but you have, for instance, also Joseph Stiglitz, a Nobel Prize, who has written extensively in the area of intellectual property, also arguing that intellectual property is not the driver of innovation, and very critical of the way in which the United States has increased the level of protection in that area. This is a book by James Bessen and Michael Moyler, Patent Failure: How Judges, Bureaucrats, and Lawyers Put Innovators at Risk. And they also made an analysis of different studies on patents and innovation, and concluded that nations with patent systems were not more innovative than nations without patent systems. Similarly, nations with longer patent terms were no more innovative than nations with shorter patent terms. So again, two scholars from the United States who conclude that the relationship is quite weak. Scherer is one of the great economists of the United States, Harvard University. He has worked in the area of structure of markets a lot. And he has worked also in the area of patents, including pharmaceuticals. And then this is from one of his papers in this area, where he concluded that economic studies have shown repeatedly patents do not play a particularly important role in most fields of industrial innovation. So again, he studied a large number of patents, and his conclusion was that that linkage between patent and innovation was not so strong. Well, this is a study published by WIPO, the World Intellectual Property Organization, as you know, an organization whose role is to promote intellectual property and increase the level of protection. And they got this conclusion: the inconclusive empirical evidence on patent strength and innovation relationship makes it difficult to draw any conclusion about the effectiveness of patent system to encourage research and development investment. Quite strong, huh? Because the assumption by many studying this area is that patents encourage research and development. That's it. Huh? And then they encourage the research and development, and therefore innovation will be obtained. But as we are seeing, most studies cannot get evidence that this is the case, and economists are very, very skeptical. I don't know what you have probably seen this, because it was published in UK. Perhaps you have already analyzed this. It's very interesting. The Economist, a very conservative journal, had an editorial note and an article on the issue of patents and innovation. I don't know whether you've seen this, and it's very critical about it. So the argument is time to fix the patent system, and essentially what the journal editorial says, the patent system is not working as it is claimed. It's not promoting innovation. It's perhaps blocking rather than promoting innovation. So very interesting, because it means that all these economic studies I'm referring to have now been reflected in a journal which has very competent people, certainly, of this kind. Well, these two guys that I mentioned before, Baldwin and Levin, they published the first book in 2007 about the relationship between patents and innovation, and they produced another paper in 2013. So after a few additional years of study, they came to the conclusion that you can see there on the screen. They said, in general, public policy should aim to decrease patent monopolies gradually but surely, and the ultimate goal should be the abolition of patents. After 6 decades of further studies since Matschrup's testimony in 1958, do you know about this Matschrup testimony? So Matschrup was a great economist in the United States. He was requested by the Congress of the United States an analysis about the impact of the patent system. And then Matschrup said, on the basis of the current evidence, I could not recommend any country to adopt the patent system. But at the same time, on the evidence I have, I cannot recommend to abolish the patent system. So his conclusion was ambiguous. Then what these two scholars say is that after so many years of this Matschrup's testimony in 1958, further study has failed to find evidence that patents promote the common good. It is surely time to reassess his conclusion that it would be irresponsible to abolish the patent system. This is what Matschrup said, that it would be irresponsible to abolish because there was no sufficient evidence. But then these two guys are saying, well, after so many years, after several decades of study, we can actually say now that, in fact, the patent system should be not even reformed, should be abolished, which shows quite dissatisfaction with the operation of the system. There's another quote from Richard Posner, a very respected judge. He works a lot in the area of law and economics. He is a judge of the United States Appeals Court, also professor at Chicago. And then he said, along the lines of the previous scholars that we have invited to this session, that in most industries the cost of invention is low, or just being first confers a durable competitive advantage. So there is no point to a patent monopoly that will last 20 years. Most industries could get along fine without patent protection. And here you have one of the main arguments of those critics of the patent system, and this is the concept of the lead time. I don't know whether you are familiar with this concept. Lead time. So this means that, well, the argument by many economists is that the mere fact that the innovator can introduce an innovation and then has several months or years until there is an imitation, this will give an advantage in the market. So this lead time will allow the innovator to recoup for any investments he has made in research and development. There is no need for a monopoly. So the argument is that in most industries, perhaps possibly thinking differently from pharmaceutical industry, so most economists think that this lead time is sufficient in order to get the reward of innovation. There is no need for a monopoly. For instance, in the case of integrated circuits, just to give you an example, when a new microprocessor is developed, and it's a new and interesting or powerful microprocessor, what the company that has developed the microprocessor will generally do is to enter into contracts with the producers of laptops, computers, so on and so forth, in order to supply on a same base, on a regular base, this microprocessor. Okay? But the microprocessor may be imitated, so another company may look at this microprocessor and through techniques of reverse engineering get a microprocessor with the same functions or the same qualities. This may take a few months. But since the first innovator has already established agreements with producers of laptops and computers, he has this advantage because for laptops and computers producer, it's not a good deal just to change in a few months the supplier of the microprocessor, because it will have the same functions but will be different. They will have to adapt again the operating system, so on and so forth. So this is a clear example of lead time. Some economists have worked on this, and for instance has shown that in the case of semiconductors, the production of chips and microprocessors, intellectual property plays practically no role. It is everything about lead time, and intellectual property, patents, or other forms of protections are not relevant. Okay, then just to conclude on a more positive note, because you could say, well, then if patents do not promote innovation, therefore there is no innovation, there is no development, so what can we do? Huh? So where is the solution? Well, as we have seen, what some economists argue is that indeed, if we want to promote innovation, we need to strengthen competition, not monopolies, not exclusive rights, but rather put companies to compete. And this is a paragraph which I think it's interesting, also coming from the United States federal body, the Federal Trade Commission, that published a very interesting report on the proper balance of competition and patent law and policy in 2003. And this report says, competition can stimulate innovation. Competition among firms can spur the invention of new or better products or more efficient processes. Firms may race to be the first to market an innovative technology. Companies may invent lower cost manufacturing processes, thereby increasing their profits and enhancing their ability to compete. Competition can prompt firms to identify consumers' unmet needs and develop new products or services. So interestingly, this body, of course, one of the tasks of the Federal Trade Commission is to protect competition, is that, in fact, if you want more innovation, you need to protect competition and not to limit that. Okay, well, this is the situation of the debate. As I said before, you will find some studies that may lead to different conclusions, in particular econometric studies that attempt to show that there is a relationship between the level of foreign direct investment, for instance, and the strength of intellectual property protection or patent protection. There is a recent study by Keith Maskus, which shows that there is a correlation between strong intellectual property protection and exports. So the countries that have strong intellectual property have a better position in terms of exporting goods. So there is a correlation, but of course there is no evidence that this enhanced capacity to export is because of intellectual property or other factors. So there are many studies like this, but I would say that the dominant trend today, in particular among economists in the United States, there are less analysis, I would say, in Europe, but in particular the United States, is along the lines I have just presented. Is a very skeptical view about this relationship between intellectual property and innovation, or intellectual property as an incentive to research and development. And clearly we have seen that in the case of developing countries, we cannot just say that the TRIPS agreement and the increase in the level of protection has had any significant impact in terms of improving the level of innovation. So just to conclude, what the standard theory would say is that in the case of developing countries, that there might be different stages of development. So it might be thought that, let's say, when the developing country is at a very low level of technological development, economic development, what we might call an initiation stage, well, we could see that intellectual property could certainly have very little or no impact at all, because there are no conditions for research and development of innovation. So even if you have intellectual property, if you have the strongest patent law, this will not be a magic tool. So the best system of intellectual property will not just create generate innovation or creativity if other conditions are not met. So it's not something that magically will produce such a result. So in the case of countries, for instance, least developed countries or low-income countries that I mentioned before, in accordance with the World Bank classification, clearly the intellectual property has no impact whatsoever in terms of promoting innovation. These countries are based on agriculture, mining, and these activities are not dependent on any level of intellectual property protection at all. But the system of intellectual property may have a negative impact, however. For instance, if patents are granted on pharmaceuticals, as I mentioned before, the owners of these patents tend to charge very high prices for pharmaceuticals, and then there is an impact, but it is not positive, because high prices, for instance, for medicines in these countries means that people cannot get access to the medicines. So then we may consider a situation where a country has made some progress, and it is at the level that some economists call internalization stage, where there is absorption of foreign technologies, there is some development of machineries, etc. And therefore, this could be the situation of, let's say, middle-income countries, where they are just manufacturing, but manufacturing with low value added, in some areas where technologies are relatively mature and not very new technologies. Well, in this case, again, for middle-income countries, it's difficult to expect that intellectual property will have a major impact, because these countries or the companies there are not really innovating. They are manufacturing on the basis of received technologies which are in the public domain, technologies which have been improved or got from consultancy firms, and therefore, even if there is the best system of protection for intellectual property, the impact may be very, very little or insignificant in terms of promoting innovation. But again, in this case, the impact of intellectual property may be negative on the side of preventing access to seeds, for instance, when they are protected, or to pharmaceutical products, or to agrochemicals. So there is an impact, but not necessarily in terms of promoting innovation. Then what many economists would say, and many people working in this area will say, well, that's okay, but intellectual property will become important when a country that just goes up and then is able to generate new technologies, when it enters into what is called the generation stage. That means that at that time, the country is not just using old technologies or public domain technologies, but is able to innovate. So the theory would say that at that stage, for instance, today perhaps the case of China, when a country is at that stage, then intellectual property may become an important tool in order to promote research and development and innovation, so on and so forth. The negative impacts will be there in any case, in particular if some areas continue to be dominated by foreign companies, such as pharmaceuticals. But the argument would be that to the extent that there is this path of development, intellectual property will become more relevant, because there will be companies interested in funding research and development, so on and so forth. So this is what could be said in terms of development and intellectual property. The problem we face now is that if we look at the literature that I have just presented, there is a lot more about this. Coming from developed countries, this literature is saying, well, no, even for us, this is not working. The system is not working. The economists have said, we need to fix the system. It's not working. So this model of gradual increase in the relevance of intellectual property as countries develop is not actually confirmed by the literature that we know about in the case of developed countries. So we still have then an issue to do research on. Clearly, it's very difficult to make a statement on this relationship between intellectual property and innovation, unless to say something about the relationship between intellectual property and development, because we are not really sure about even the extent to which intellectual property promotes innovation. Okay? Well, like this, I think I have taken more than the
Huh?
That's
Huh?
absolutely within
More
the
than the
parameters of-
allocated time.
Yeah.
Well, thank you very much for your attention.
Well, thank you very much, Carlos, and I think you definitely deserve a round of applause for